is 42860D1. And that is the code section that allows your honor to resentence the defendant as otherwise provided by law. Otherwise provided by law. I think that's an important concept for your honor to think about. Otherwise provided by law includes the court's power to impose consecutive sentences. It is 42860D1. That is the code section. I would ask the court to take judicial notice of the plea transcript from.
Now, I have read the police transcript, and he was clearly put on notice.
So to that point, Mr. Sharp, would your honor take judicial notice of the plea transcript?
Yes, sir.
Thank you.
It's part of the record.
Mr. Sharp on page 8 of that plea transcript says he's explaining it to Mr. Eppinger about one of the consequences of first offender. He says they can resentence you up to the maximum of what the charge carries. Okay. The state on page 9 says if you violate any terms of your first offender status, could be revoked, could be adjudicated guilty, could be resentenced up to the maximum sentence for each charge in the indictment. Not exactly correct. It's each charge you plead to, and the charges he pled to were different than the indictment. And then your honor asked Mr. Eppinger if he understood the benefits and consequences of his first offender treatment. Uniform Superior Court Rule 33.8 says that a judge should not accept a plea of guilty from a defendant without first, and so paragraph D of that, informing the defendant on the record, and section 3 after that, of the maximum possible sentence on the charge, including that possible from consecutive sentences and enhanced sentences, where provided by law. Okay. At no time was Mr. Eppinger ever informed of the fact that this court had the power to impose consecutive sentences if he were to violate his first offender probation. Just wasn't done. He was 16 when he took that plea.
And he got a break.
He did get a break.
And he went out and continued to commit violent crime. And he's here today because he tried to murder a police officer.
I understand that. And we're here today to decide what the sentence is. And I am arguing to this court that because of 42861, where this court is supposed to ensure that the defendant is made aware of the consequences of entering a first offender plea pursuant to the terms.
Well, let me ask you this. What do you think an appropriate sentence is?
So my thought is that I agree with Mr. Geary to some extent. The robbery, the sentence, maximum sentence is 20 years. I do not believe this court can impose consecutive sentences, though. And so on the count 3, aggravated assault, you can impose a 20-year concurrent sentence. He would get, of course, credit for the time he has served, which would date back to May 11th of 2016. So it's roughly 6 years.
So basically, you're saying that all of these sentences should run concurrently, and the maximum he should be sentenced to is 20 years.
I think that the possession of a firearm during commission of a felony has to be consecutive.
So it'd be 25 years.
So it would be 25, I think, is the maximum sentence. Now, I would also tell the court, I didn't have a lot of time, but I did a lot of research. And I tried to read all the first offender cases that I could find. And I found 2 where defendants had been sentenced to consecutive sentences and had challenged those sentences on appeal. And in both of those cases, the defendants lost because the judge in both of those cases had made the defendant aware of the possibility that they could receive consecutive sentences if they violated.
I've read the transcript, and I think it's sufficient. Thank you, Mr. Phillips. Mr. Gary, do you have a response?
I agree with the court, Judge. I think the warnings and the information given by both counsel on the record and the court on the record, Judge, was sufficient to put him on notice that he could be sentenced up to the maximum permitted on a revocation as he could in court. and that would have been 64 years.
Anything further, Mr. Phillips?
Yes, Your Honor. I also would argue to the court that the sentences where such, for example, the easiest examples are counts 7 through 11, 8 through 11, where there were 12-month concurrent sentences. Those sentences, he served those sentences. I would argue that because those sentences were imposed concurrently and he has completed those sentences, he has served time for those sentences, that this court is not then empowered to convert those sentences over into consecutive sentences, which would mean you're sentencing him for time that he's already served that he now cannot get credit for if you impose them consecutively.
What is your response to that, Mr. Gary?
No, I think the law is contrary to what counsel has just stated. DOC, that's their responsibility to ensure no one exceeds their sentence. He's going to get credit for the time he served both in the Fulton County Jail before sentencing, which was accurate because he committed the crime on May 11th of 16, and he got out on May 10th, exactly 4 years later, which is the sentence of the court. He's been in jail now since February 7th of this year based on this shooting. By statute, our good sheriff will do the documentation to give him credit for that based on his new sentence. And then DOC will give him credit for what he's already served. Judge, respectfully, I believe if you give him credit and reduce the sentence, he's going to get credit for that time twice because DOC is obligated to do that. And I'm not sure you can do a sentence where you refuse to give the defendant credit for time served. So it's going to happen. You sentence him to 20 years, he is going to get credit for every day he served, Judge.
But my issue is slightly different. If you stack the 12-month sentences at the end of the sentence, as Mr. Geary is asking you to do, he says you have 64. Essentially, if you add up every maximum sentence for every charge he had, you come to 64. I believe that's correct. If you stack those where he's already served them, there's no way for him to get credit. He'll get credit for 5 years or however much time has elapsed. I don't believe there was ever a tolling warrant taken out in this case, but separate issue. He gets credit for the 5 years, but the sentences he's already served and gotten credit for, if you then take them and slap them on the end of the sentence, that adds an extra year and takes it outside the initial 5-year period where he would get credit. So you're actually sentencing him twice for those offenses. And I don't need to tell Your Honor, that's not permitted.
Well, respectfully, I disagree with you. I'm going to let the appellate courts sort that out.
Do that.
This is the kind of case that's going to make judges and prosecutors rethink giving a 16-year-old a break. He's clearly in a gang. He's dedicated his life to violent crime, and he's an absolute danger to society, and he belongs in prison for the rest of his life. That's for another judge. My job is to find what the correct sentence is here today, and I hereby am going to sentence him to 64 years in prison, and I'm going to accept the state's recommendation. And then I imagine Sheriff Labatt, he'll be in the Fulton County Jail pending resolution of the attempted murder of the police officer.
We will probably make other arrangements and transport.
Well, it's certainly up to your wisdom. Thank you for the good job you do, Sheriff.
Thank you, Judge. Thank you.
All right, we'll stand in adjournment.
Who's Mr. Phillips? Mr. Gary.
Don Gary?